For
Good afternoon, members. I call Committee of the Whole on Bill 39, Zero Emissions Vehicles Amendment Act to order. We are on Clause 12. Shall Clause 12 pass?
Aye. Nay. Division.
five.
Division has been called.
And then I think
Members, we
Yeah.
apparently it started prematurely. The House business has not yet to be called, so we have to start again. A do-over. We'll take a short recess until we get everybody. Good afternoon, members. I call Committee of the Whole on Bill 39, Zero Emission Vehicles Act, back to order, Amendment Act back to order. And we are on Clause 12. I'm advised to say can make clauses 12 to 17 pass.
On division.
On division.
Great.
Great, okay. All those, I haven't called, all those in favor?
On division.
Opposed?
On division, or you want a standing vote, or? on
Nope.
division?
Okay.
Clause 18.
So ordered. On Clause 18, member from Kelowna Mission.
Thank you so much, Chair. To the Minister, what is the purpose of having a forecast report? What kind of information will be prescribed in this, and will there be any consequences if forecasts are not met?
Minister.
Thank you very much, Chair. Yes, this is a new provision in the Act, and the purpose is to add a new requirement It'll require suppliers to submit a forecast report that contains information about the anticipated supply of motor vehicles that'll come with each model year report. Now, there currently is not a requirement to submit such a report. The purpose of it, it really is essential to the province in tracking the ZEV market as it progresses. This is something that's been learned from other jurisdictions that do have this requirement. And it will help the province make informed decisions about investments in ZEV infrastructure, charging infrastructure, for example. And it'll help to inform any potential future changes to the ZEV Act. And yesterday we talked quite a bit about different mechanisms that are in place to be adaptive and responsive to things, and not quite in real time, but as the results roll out. And this is an essential tool for being able to do that better. If a supplier fails to submit it, there is a prescribed penalty, and that is described in the Act. Thank you.
Member.
So if there are negative, if this reporting happens to notice a negative trend within the forecasting, would this be an opportunity then for the advisory council or whatever body that information goes to adjust the ZEV targets, or would that have to come back to legislation?
Minister.
Yes, this is one source of information that could be used by program staff, by the Zero Emission Vehicle Advisory Council, that will provide feedback into the program design. The Act prescribes the sales targets at milestone years, so 2026, 2030, and 2035, but the regulation describes the in-between period. So there would be an opportunity to amend the regulation in between those milestone years. If the sales targets, if it was deemed wise to change the sales targets in those milestone years, then that would have to come back for legislative amendment. Thank you.
Shall Clause 18 pass?
Aye. Nay.
On division.
On division, so ordered. Shall Clauses 19 to 32 pass?
Aye.
On
Nay.
division.
So ordered on division. Shall the title pass?
Aye.
On
Nay.
division.
So ordered on division. This committee stands... Nope. Oh, no, I need to hear the minister now.
I have an amendment.
Wait for an amendment.
It's too late.
I'm sorry, it's too late.
That ship sailed.
This is the motion.
Honourable Chair, I move that the committee rise and report the bill complete without amendment.
Members, you've heard the question. All those in favor?
Aye.
Opposed? So ordered. This committee stands adjourned. Good afternoon, members. I call Committee of the Whole on Bill 43, Money Judgment Enforcement Consequential Amendments and Transitional Provisions Act to order on Clause 27, recognizing the member from Abbotsford West.
Honorable Chair, at the beginning of these proceedings, before the lunch break, I asked a couple of general questions, and I neglected to ask the ultimate follow-up question. We're dealing with these consequential and transitional amendments as part of a separate bill. We talked about that briefly and how that happened. The question I didn't ask, which I suppose I should, is was there a particular reason the attorney chose to table the bulk of the consequential and transitional provisions in a separate piece of legislation?
Attorney General.
Thanks for the question. So that we introduced the legislation in spring and allowed people to get a sense of it, and then we were able to take the time necessary to think about the consequential and transitional provisions. As we talked about, it's a very large piece of legislation impacting many different other pieces of legislation. So it was just the time that we needed to have to do that.
Member.
Thanks, and to the attorney. Back to 27, I did just want to pursue this question a little bit. And again, like the main piece of legislation, examples are helpful here. So I have commenced an action against a First Nation. It may be a BC First Nation that has business interests in Alberta, or an Alberta First Nation. And, well, I went through the example of the cultural artifact that comes to British Columbia temporarily under the previous creditor's remedy regime. That item was exempt from seizure. And I just want to be clear, as a result of the amendment in clause 27, that cultural item is no longer exempt, and the attorneys and could be seized. And the attorney's answer to that is that to the extent that a First Nation has concerns about that, it would be up to the enforcement officer to decide whether or not that item was to be seized. Although my recollection of the legislation is that the judgment creditor would be in a position to direct that if that was the only asset, available. The judgment creditor would be in a position to direct the enforcement officer to seize that item, and it would be exigible as a result of this amendment.
Attorney General.
I think the member has articulated a very complicated situation that many factors would make it so it would fall outside of this piece of legislation. But of course, it's fact-specific and art-specific, so I'll just give a general sense of what would be at play in this matter. So first of all, ownership when it comes to First Nation is communal ownership and guided by a whole area of law. So I think quite at the offset, it would fall down based on that, whether or not it's one particular owner or not, or even up to the First Nation government to be able to give authority or ownership over something that's communally held. The second is that there's a potential for other pieces of legislation to be party to that, including heritage or artifact conservation legislation we have in BC that would make it so it was outside of this. And also, if it was on reserve, we wouldn't have any authority on reserve land under this legislation. And then even if you were able to pin it to one individual ownership of that through the workings of the provisions we put in place, a third party like the nation government could come in and intervene to protect that piece if it's of importance.
Shall Clause 27 pass? Aye. So ordered. Shall Clauses 29, Clause 20, on Clause 28. Member?
Thanks, Honourable Chair. Just wanted to confirm that the change here is the replacement of the term court bailiff with civil enforcement officer.
Attorney
Yes.
General?
Yes.
Shall Clause 28 pass?
Aye.
So ordered. Shall Clauses 29 to 32 pass?
Aye.
So ordered. On Clause 33, Member?
Aye.
One of the things I resolved 100 years ago when I left law school was to never repeat the word novation. But I have broken that vow today. Merely to ask the attorney two questions. Is this the provision that seeks to, under the new creditor's remedy regime and money judgment enforcement regime, seeks to perpetuate the general rule around novation, and I'm not being mischievous here, if I am correct and this is the general rule relating to novation in mortgage and mortgage foreclosure situations, if she could summarize what the practical effect of these provisions are when a foreclosure occurs.
Attorney General.
Okay, so the purpose of this provision is to, I guess, force a choice, right? You either are foreclosing on a house or a property to satisfy your debt, or you're using the money judgment enforcement in a different way. So it just sets up that. So in an example, if you've already initiated a foreclosure proceeding on a property, then you are prohibited from using the other enforcement mechanisms for the same debt.
Member.
And in that respect, and this is the question, are there any substantive changes? Does this affect any substantive changes around the creditor remedies or the means by which creditor remedies operate with respect to a mortgage and mortgage foreclosure? My sense is it does not, but that's the question.
Attorney General.
It does not.
Shall clause 33 pass?
Aye.
So ordered. Shall clauses 34 to 42 pass?
Aye. 41.
41.
I have a question on 42.
Okay, so shall clauses 34 to 41 pass?
Aye.
So ordered. On clause 42, member.
Thanks, Honorable Chair. And just to be clear, the Creditor Assistance Act, and I'm obliged to our staff for having located it here in the attic. As with the Court Order Enforcement Act, but in this case, the attorney in the legislation purports to repeal the Creditor Assistance Act in its entirety. Is there any need for transitional provisions, or does the money judgment enforcement legislation capture in a timely way all of the necessary provisions contained within the Creditor Assistance Act?
Attorney General.
Thanks. So yes, the Creditor Assistance Act is no longer needed, and the specific reason for that is because the whole purpose of it was to share pro rata with the judgment creditor, but that's covered now under the Money Judgment Enforcement Act, and there is a transitional provision related to this. We haven't pulled it up, but if you'd like me to, we can look for it.
Shall clause 42 pass?
Aye.
So ordered. Shall clause 43 pass?
Aye. And I can probably help us, Madam Chair, fairly significantly.
Was that so ordered on 43?
Not yet. I'm waiting to see what he says.
I think 42, you said so ordered
We
though.
can go,
No.
we can pass up to section 71.
Okay.
Aye.
It is now. Just one more time.
So ordered. Shall clause 44 through to 71 pass?
Aye.
So ordered. On clause 72, member.
Thanks, Honorable Chair, and I'm on 72, which adds to the Land Title Act a section 211.1 and 211.2. I'm looking at 211.2, which is in my copy of the bill on the next page. And I wondered if the attorney could explain the 2-year expiration. This creates a 2-year expiration versus the the expiration period under the Money Judgment Enforcement Act and explain what I believe is a difference between the length of the enforcement and the length of the expiration of the period of time, the 2-year period versus the Money Judgment Enforcement Act.
Attorney General.
So this one is not a change from the Court Order Enforcement Act. It reproduces the 2-year limit, and the reason is after a consultation with the Land Titles Office, they felt it was important to retain that 2-year timeline out of the need to make sure that all their registry or titles remain current.
Shall Clause 72 pass?
Aye.
So ordered. Shall Clause 73 pass?
Aye.
So ordered. Shall Clause 74 pass?
Aye.
So ordered. Shall Clause 75 pass?
Aye.
So ordered. Shall on Clause 76, member.
Thanks, Honourable Chair. So this is a question that probably has relevance. We're now into the transitional provisions, Part 9 of the bill, and I'll ask the attorney to put on the record what the general intention here. I presume it is to allow for a seamless transition for those who have money judgments under the existing regime to transition into the enforcement capacity offered by the new legislative regime, which, as I recall from our earlier conversation, isn't likely to take effect until be operational until the latter part of next year or even 2025. I can't remember. The minister answered that question, and I can't remember what the specific answer was, end of 2024 or into 2025. The minister can clarify that in a moment. The point being that if you are a person today seeking to go before a tribunal and secure a judgment and become a judgment creditor today, for the foreseeable future, well, for the next year or two, you are going to be operating under the existing enforcement provisions. These next sections that we're dealing with allow you to transition eventually, in fact, require you at a certain point to transition to the new regime. And if the minister can confirm the general accuracy of how I've described it, and then secondly, the question I'm going to have is, what additional payment of fees does that transitioning require? Does the transition occur automatically? We talked a few moments ago about pushing a button and having the to notify for the civil dispute tribunal notifying the registry. Is this going to be a similar exercise where there's an automatic transition, or as a judgment creditor, am I going to have to go and am I going to have to pay a whole series of additional fees to move into the new regime?
Attorney General.
Okay, so the purpose of these provisions are, as the member correctly stated, before this comes into force, which we're expecting in early 2025, the existing rules under the Court Order Enforcement Act would apply. So if somebody does have a writ that they've received under that normal proceedings, then they can use that to enforce their rights up to usually the 1-year expiration date. So the timing of that is linked. And then if they choose to transition to the Money Judgment Enforcement Act, yes, they would have to pay the fees, which we described, I think, at length about our desire to make sure that those fees are nominal and that there's a high access to justice from that. And then they will be able to avail themselves of all the different tools that the new regime will have in place for them to get their debt satisfied.
Member.
Thanks, Honourable Chair. This is most assuredly a procedural question. So I am a judgment creditor who has received my judgment from the small claims court in the spring of next year, and that I secure on that in order to execute on that judgment a writ of execution that is valid for 1 year. So I'll just use the dates: April the 1st of make it May the 1st of next year. My writ of execution expires on May the 1st of 2025. At that point, pursuant to what will be 77 sub 4, 77 sub 4 of clause 77 sub 4 of this act, is that what requires me at that point? I won't be able to renew a writ of execution. My only option will be to register and transition over to the money judgment enforcement regime.
Attorney General.
Yes.
Shall Clause 77 pass? Aye. So ordered. Sorry, I'm out of order. Shall Clause 76 pass?
Aye.
So ordered. Shall Clause 77 pass?
Aye.
So ordered. Shall Clause 78 pass?
Aye.
Recognizing the member from Abbotsford West.
Just want to check here, we are dealing with proceedings against land. There's a deeming provision here which suggests to me that the judgment creditor in this case doesn't need to do anything. That the registration against land, it represents, it is deemed to be properly registered under, and that will continue under the new regime. Am I correct in that regard?
Attorney General.
So the answer is yes to what the member's question was, and the reason behind it is so you don't lose your priority that you may have had.
Shall Clause 78 pass?
Aye.
So ordered. Shall Clause 79 to 81 pass?
Aye.
So ordered. Shall the title pass?
Aye.
So ordered. Minister.
So before I close this off, I just want to acknowledge the hard work of my team here. We had Natalie and Tyler sitting beside me for most of the time, but this work goes way back to just this committee stage and all the dedication and improvements, and it's always nice when we can reform justice systems to have people be able to access the remedies that they should seek in their system in a more meaningful way. And I just want to acknowledge the years of work that this took and really just congratulate the team for my ministry for getting to this stage. So, Honourable Chair, I move that the committee rise and report the bill complete without amendment.
Members, the question is that the committee rise and report on Bill 43, complete without amendment. Are those in favor? Aye. Opposed? Carried. This committee stands adjourned.
Good afternoon, members. I call Committee of the Whole on the Miscellaneous Statutes Amendment Act number 223, Bill number 42, to order. Shall clause 1. Oh, Minister.
Thank you, Chair. I just wanted to welcome the staff team that is now joining me here, and a special shout out to Dotan Amit, who's this is his first time in committee, but also overseeing the first piece of legislation, has joined my team, so everybody can welcome him. It's going to be a good process, I think. And Natalie Barnes as well. Thank you.
Shall clause 1 pass? Recognizing the member from Abbotsford West.
Thanks, Honourable Chair. Welcome again to the attorney and to her able staff, some of whom are here for the first time. I have a few questions really about part 1 of the bill in its entirety, so that'll be sections 1 through 15. I'll ask them all as part of section 1, and we won't have to pursue it further. The upshot is the replacement of the term master with associate judge. First question that I suppose the attorney should probably put on the record: the impetus by which the change is being made in the first place. The term, for those who practice in the courts, master, long-standing term. It's changing. What was the impetus for that change?
Minister.
Thank you. So as I'm sure the member would agree, words matter, and especially when people are entering the justice system and encountering what can be a very intimidating system. So I know that it's long been advocating for by our Chief Justice Hinkson of the Supreme Court, and we were glad to make the changes. We think it's part of the court being more accessible and open to people, and removing words like master, I think, are part of that.
Member.
Thanks. So specifically a request from the court itself, from the Chief Justice.
Minister.
That's correct.
Member.
Second question, simply to confirm, nothing in these 15 clauses, provisions, alters the jurisdictional authority of what was a master and will now be an associate judge. They largely grant temporary, or what the lawyers call interlocutory, orders on applications of that sort. They have some other jurisdiction as well, but the point is the change in name is not changing in any way, shape, or form the jurisdictional authority that the new associate judge, formerly masters, will have.
Minister.
That's correct. It's a change in name, but not any of the other powers.
Member.
And my last question might seem like an odd one, but so what's the proper form of address now when appearing before? It won't be associate judge. Will it be Your Honor? Will it be my Lord? What will the appropriate term of address be when appearing before an associate judge?
Minister.
Thanks. So the terms "my lord" and "my lady" have gone by the wayside, thankfully. But in this instance, it would be associate judge would be the term.
Minister. Member.
Sorry, I don't mean doesn't matter to me but it seems odd. I don't think people would appear in court and refer to associate judge. I think they would it might be Your Honor, it might be, but I don't think it would be, yes, associate judge. Has anyone given any thought to, in the case of a master, it was in my day Your Honor. But what would the proper form of address be? Because there is a difference. These are not full Supreme Court justices. They are associate judges.
you make it so that? Minister.
Thank you. So this is something that wouldn't be obviously contemplated in the legislation, but in the purview of the Chief Justice of the Court. So I'm just informed by letter that the Chief Justice Hinkson has said he would ask people to properly address them as judge, and then the surname.
Shall clauses 1 through 15 pass? Aye. So ordered. How many clauses are there?
I think this is where the attorney is going to say, I'm out of here. So if we might recess for just a moment, Madam Chair, and we'll determine what the next ministerial level exchange is going to be.
Okay, this committee is now in recess until we have the next minister and staff. Good afternoon, members. I call the Committee of Whole. No, you don't want to do that? Yeah, that's what I was about to do. I call Committee of the Whole, Bill 42, Miscellaneous Statutes Amendment Act Number 3, 2023, back to order. We are on Clause 16. Shall Clauses 16 through 24 pass? Aye. So ordered. On Clause 17, recognizing, oops, sorry, on Clause 25, recognizing,
You could call clause 25 as well.
oh, all right. Shall Clause 25 pass? Aye. So ordered. Shall Clause 26 pass?
Now you're probably looking at a ministerial shift.
Oh, no.
Sure hope so.
Okay, I call a recess until the next minister, staff, and critic are all in place. Hopefully that will be fairly briefly. I call Committee of the Whole on Bill 42, Miscellaneous Statutes Amendment Act Number 3, 2023, back to order. We are on Clause 26. Shall Clause 26 through 69 pass? Aye. So ordered. On Clause 70, recognizing the member from West Vancouver, Capilano.
Thank you, Madam Chair. So on Clause 70, actually to 72, language is changing regarding ending tenancies to require the landlord to pay a penalty to unless from does not. Can the minister explain why was this change made? And does it increase the scope of the landlord's obligations under the section?
Minister.
No, it does not.
Member.
Thank you. The first part of the question was why was the change made?
Minister.
Thank you, Chair. It's a housekeeping measure. It's to align with changes that were made 2 years ago.
Member.
Thank you, Madam Chair. So just to clarify then, it's housekeeping, so this change is not going to have any impact on decisions at RTB, but the reason is for housekeeping. So what is it, if the minister can explain also, what is that aligning with?
Minister.
Thank you, Chair. And I already said it doesn't have, it's housekeeping, but it's a housekeeping amendment to align the onus and test for compensation with Section 51.2.
Shall Clause 70 pass? Aye. On Clause, so ordered. On Clause 71, shall Clause 71 pass? Aye. So ordered. On Clause 72, shall Clause 72 pass? Aye. So ordered. On Clause 73, recognizing the member.
Thank you, Madam Chair. So this is dealing with timelines and establishing priorities for dispute resolution for RTB. Can the minister explain through the chair, how will this actually ensure the RTB decisions are timely?
Minister.
Thank you, Chair. So this is it's an overarching principle statement. So tenants and landlords will be able to get through the dispute resolution process more quickly and easily, meaning they will get a resolution to their dispute faster.
Member.
Thank you, Madam Chair. Thank you to the Minister. How will it be determined that this is being successful? I mean, are there actually going to be numbers attached to this in terms of expected time?
Minister.
Thank you, Chair, and this takes me back to estimates because we canvassed this at great length, and I shared with my friend across the way that we track call times, we track a whole host of measures, and that's how we'll be tracking the results from this.
Member.
Thank you, Madam Chair. So in estimates, the Minister promised that there would be more FTEs at the RTB. And in estimates, we learned that only half of the positions that had been committed to had been filled. Can the Minister tell us how many FTEs have since been filled?
Minister.
Thank you, Chair. I don't want to get too far into estimates, but I will share with the member that 45 of the 50 that we were hoping to hire have been hired.
Member.
Thank you to the Minister. Thank you. What are the current wait times for all three categories of RTB hearing? So that's money, standard, and emergency. And how does this compare to the previous 2 years?
Minister.
Thank you, Chair. I can't give the member the information now for 2 years. I can give the member from last year, if that works. So we've seen a overall 32% reduction. We last year, the same time, we had 4.3 weeks for emergency applications. It's 3.1 now. We had 16.3 weeks for a standard application. We're at 11.2. And monetary claims alone was 35 weeks, and now we're at 19 weeks.
Member.
Thank you to the Minister. What is the average call wait time at the RTB, and how does this compare to previous year?
Minister.
Thank you, Chair. And as I share with the member, we've made significant improvements. For example, percentage of calls that were answered within 20 minutes. I think I shared with the member last time that we were at 59% of the calls were answered within 20 minutes. This month we're at 90%. The average wait time before a call gets answered was last year at 23 minutes and 8 seconds, and now it's 8 minutes and 23 seconds.
Shall Clause 73 pass? Aye. So ordered. On Clause 74 through... Shall 74 and 75 pass? Aye. So ordered. On Clause 76. Member.
Thank you, Madam Chair. Okay, this enables RTB to assess claims for damages under 49.2. This exempts rent evictions from the small claims threshold. What will this impact have on RTB wait times?
Minister.
Thank you, Chair. And I would say to the member that it's not quite how the member characterized it. This is also a bit of housekeeping. So it clarifies for the purpose of determining whether the director may resolve a dispute that compensation received under an order made under Section 49.2 of the Act is excluded from the calculation of the amount claimed. So repairs. And so, yeah, this again is part of the housekeeping.
Shall Clause 76 pass? Aye. So ordered. On Clause 77, member.
The threshold is very high when we're trying to look at whether something is a vexatious application or frivolous. How will that be determined by the director?
Minister.
Thank you, Chair. So there will be some policy guidelines put in place around this, but examples would be individuals that they're repeat visitors, they continue to come, or they try to use the process to harass the other person, or there's court decisions that impact it. But that's the frame of what it would be, and the policy guidelines of how it would put in practice will be developed.
Shall Clause 77 pass? Aye. So ordered. Clause 78 through, shall Clause 78 pass? So ordered. Aye. Clause 79. On Clause 79, member?
Thank you, Madam Chair. Would this provision enable the director to require two parties to proceed to a facilitated settlement, or does it remain optional under this section?
Minister.
Thank you, Chair. People would be required to go through the process, and if it's not successful, then of course they would go through the normal process.
Shall Clause 79 pass? Aye. So ordered. Shall Clause 80, on Clause 80, member?
What type of reasons would there be to dismiss an application that's going to be added to regulation? So just an example of what's being contemplated.
Minister.
Thank you, Chair. So applications with no possible chance of success, director was not notified of the application being served, or dismissing an application for dispute resolution.
Shall Clause 80 pass? Aye. So ordered. Shall Clause 81 pass? So ordered. Shall Clause 82 pass? On Clause 82, member?
Can the minister provide an overview of how the facilitated settlement process will work going forward?
Minister.
Thank you, Chair. So the type of disputes that will be targeted initially in this pilot project are things like repairs, orders for landlords to comply with the Act, monetary disputes under $5,000, and disputes about rent increases. Over the course of the pilot project, the RTV may identify other dispute types for facilitation. And the purpose of the facilitation is to assist landlords and tenants in resolving disputes in a way that is accessible, speedy, flexible, and address the needs of all the participants.
Member.
Thank you. Thank you to the minister. Can the minister provide an estimate of the impact on wait times from having the facilitated settlement process?
Minister.
Thank you, Chair. So it's hard to say exactly on one measure. Collectively, we believe that it makes a significant difference. It's very similar to the Civil Resolution Tribunal. So not only does it help with the process, it's an important process for education, and also when a dispute is resolved together, it actually helps address future challenges as well, because both landlord and tenant figure out how to navigate these challenges.
Member.
Thank you to the minister, and I do appreciate the facilitated settlement process. I think it's a good way to move forward. Now, are the facilitated settlements obligatory, and how many parties need to consent to mediation?
Minister.
Thank you, Chair. So it would be required, but what we believe will happen is if there's multiple issues, some of the issues will be resolved, and then we only have to book a hearing time for whatever is remaining, as opposed to setting a hearing time and then having things being resolved in between and having, so it's about efficiency of the whole process.
Member.
Thank you, Madam Chair. Just so I've got a clear vision of it, so we're looking at mediation. And you're going to have people that are going to be coming in who are upset, they're emotional, they've had very difficult relationships with the other party, and now they're being put in a scenario where it's mediation. Are they in the same room? Is it going to be more dispute resolution where you've got the parties and somebody representing them and coming back and forth between rooms, or how is that going to work, taking into account the emotional level there? So.
Minister.
Thank you, Chair, and I think my friend across the way raises a good point, and in cases, there are cases when emotions are high. So first thing would be these mediations would happen either virtually through the phone, but we will be hiring, as I mentioned to the member earlier, there's 5 spots remaining, and so those are to hire skilled professionals that will help set up a framework and help facilitate those mediations.
Member.
Thank you, Madam Chair. So to confirm with the Minister, there will be options in terms of the mode of that mediation. So it can be by Zoom, it can be just on the phone, or it can actually be in person as well.
Minister.
Yes, that's correct. Through COVID, a lot of these things were happening virtual, happening by phone, more accessible to people, and so yes, that's the case.
Member.
Thank you, Madam Chair. Will those participating, and they may be able to do this now, and they probably can, but just so I understand, be able to have legal counsel with them in mediation?
Minister.
Thank you, Chair. And a lot of these cases are on smaller items, and staff inform me that it's really rare that somebody comes with legal counsel, but nothing precludes them from doing so.
Member.
Thank you to the Minister. And I believe I heard this over there, but just for Hansard's sake, what is going to be done to ensure that mediators are properly trained and settlements are procedurally sound? And are those mediators going to be, what is their background? Are they certified mediators from the Justice Institute, or?
Minister.
Thank you, Chair. Mediation training will be an important piece of it, but obviously we're looking for a whole host of skills that will be needed for these roles.
Shall Clause 82 pass? Aye. So ordered. Shall Clause 83 pass? Aye. So ordered. Shall Clause 84 pass? Aye. So ordered. Shall Clause 85. On Clause 85, member.
Thank you, Madam Chair. So we're expanding the form in which hearings can be held with this clause. Will this enable for all hearings to be recorded? We have heard complaints from individuals about inconsistencies in whether things are recorded or not.
Minister.
Thank you, Chair. They're all already recorded, so that will continue.
Thank you to the Minister. And will this be sensitive to the needs of rural and remote communities where travel and communications technology is not always consistent?
Minister.
Yes, of course, Chair. Predominantly it's done over the phone right now, so that's fairly accessible for folks anywhere.
Shall Clause 85 pass? Aye. So ordered. Shall Clause 86 pass? Aye. So ordered. Shall Clause 87 pass? Aye. So ordered. Shall Clause 88 pass? Aye. Shall Clause 89 pass? Aye. So ordered. Shall Clause 90 pass? Aye. So ordered. To confirming for Hansard that Clause 88 has passed. Shall Clause 88 pass? Aye. So ordered. Shall Clause 90 through 105 pass? Aye. So ordered. On Clause 106. Shall Clause 106 pass?
Ask a question if you want to go back.
No, we're into
Okay. So,
I don't, my colleague does, that there's questions on,
okay, I call a recess while we get our next minister. Sorry. For purposes of Hansard, shall Clause 90 through 105 pass? Aye. So ordered. I call a recess. I call Committee of the Whole back to order on Bill 42, Miscellaneous Statutes Amendment Act Number 3, 2023, on Clause 106. Shall pass? Aye. So ordered on Clause 107. Shall Clause 107 pass? Aye. So ordered. This clause. No.
do I just have to meet you downstairs?
This committee shall go into recess while we get the next minister and staff in place. The whole on Bill 42, Miscellaneous Statutes Amendment Act Number 3, 2023, back to order. We are on Clause 107, shall 108, shall 108 pass? Let's do it again. Recognizing the House Leader of the official opposition.
Thank you, Chair. I appreciate that. These next handful of sections, which are the responsibility of the Jobs Ministry, really are straightforward in so far as what's provided for in the legislation. The top-up of funding for each of these three trusts, the Island Coastal Trust, Northern Development Initiative Trust, and the Southern Interior Development Initiative Trust, or ETSI as it's called. I'm going to ask a few questions just about the funding, and then I've got some other more general questions about that each of these trusts have sort of identified in letters to the minister with respect to suggested amendments that these trusts had hoped the government would consider. And I'm hoping that the minister will be willing in this engagement to just provide some answers or some her feedback on things that the trusts had really hoped to see that didn't end up in these amendments. And perhaps to the minister, just wanted to make sure what her preference would be if she would like me to do the general questions kind of all in this first section. And then we can talk about the funding in each of the respective trusts, or does it matter to the minister? Does it? No preference? Okay, thank you. So first off, with respect to the funding, again, very very straightforward in terms of the top-ups that are provided for, and that certainly the official opposition supports. I guess my first question to the minister just would be, as with any expenditure of dollars that is focused on economic development initiatives, which these are, I'm wondering if the minister could provide some details for us as to how the minister, or what measurements the ministry uses to track the impact of these investments.
Minister.
Thank you, Chair. Each of these boards are independent of government, and each of these trusts, and they report out annually to their communities and to the public, and those annual reports are available on their websites.
Member.
Does the ministry have any performance indicators that the ministry kind of a lens that the ministry looks through with respect to the provision of an investment of $10 million in each of these trusts, and and the payback, the return on investment, and insofar as these taxpayer dollars being invested? Are there any performance indicators that the province has in place to track the effectiveness of these investments?
Minister.
Yeah, thanks. Similar to the first question, each of these organizations is separate from government and their report outs are provided, but I will say that, certainly we have reviewed and get the opportunity to review these report outs and see the, quite honestly, excellent leveraging that these organizations are able to do with the investments that we make in them. So it's not a requirement. The KPIs are not a requirement to government, but they are available and worth looking at.
Member.
Thank you, Chair. So I guess the answer, what I heard there was that there are no performance indicators. The organizations report out, and the report out is what it is. I'm wondering if the minister, she would be well aware that there's different leveraging models employed with these trusts. In some cases, the investment is the principal is leveraged over a longer period of time. In other cases, there's more of a grant type model where the dollars, the principal that is provided through these funding allocations like this is actually just spent down. Very different models. I'm wondering if the province has done any work on really assessing again, from a performance perspective, these different models, the different leveraging models that are used to really determine which models and which tools used by these different models actually provides better bang for the taxpayer's dollar.
Minister.
Thank you, Chair. It's my understanding at the time that these trusts were originally stood up, each trust had the opportunity to make a decision about the investment model that they would employ. Some trusts did direct impact investment. Other trusts set up an endowment-style fund. The investment that we're hoping to make with this piece of legislation, the $10 million each for the 3 trusts, provides about a 4-year runway for us to do some of the work that's needed in terms of the analysis of the different types of investment models and where we're going forward.
Member.
Thank you, Chair. Well, I'm happy to hear that there will be some analysis for this, as the minister says, runway period over the next 4 years. But again, it begs the question, has there not been any analysis done over the past 4 years or the past 8 years? Any analysis to determine within the ministry the effectiveness of the different models that the minister has acknowledged exist. And at the end of the day, these are the programs, the investments that these dollars have been invested in, and again in different ways, have had huge positive impacts in the communities and the regions for sure. But but some models, there's a complete drawdown on the investment that's or the principal, if we can call it that. In other models, there is a leveraging of that principal in a different way. So I just want to ask one more time if the minister can say, has there been any analysis done on the effectiveness of these different models over the past, pick a time frame, the past 4 years, past 8 years, that would have informed, in part, the government's decision to move forward today with the request through this legislative process for the advancement of additional, $10 million to each of these trusts.
Minister.
Yeah, just as I stated prior, that is part of the work that we have ahead of us.
Member.
Thank you. It's easy to just say no, I guess. So we'll circle back as part of the estimates process, I'm sure, next year in the budget and so forth. But I find it very interesting that the minister can't and won't indicate that there's been any analysis done. It's all we can infer with an answer like that there hasn't been any analysis done on the effectiveness of these different models and the leveraging of the investments that each of them employs. We're talking about $30 million of taxpayers' money moving forward. So good news to hear that there appears to be some work on analysis moving forward, and we'll pick that part of the discussion up at a later date. So I just wanted to move now to just a few general questions. The three trusts work very, very closely together, and they have a very collegial relationship. They often, as the minister knows well, they write letters. Often they're joint letters. They certainly share information. They've also been very good over the years with successive governments in power at being very inclusive of all of the MLAs that are within their region. So I certainly know when I was in government, I had a certain level of access to ETSI in the Southern Interior. I have the same level of access to ETSI as an opposition member now, and I think that's an important feature of each of the three trusts, that they work very closely with all of the MLAs regardless of political party. They work with all of the local governments in their regions and many other organizations and stakeholders. So that's all very good. And I say all that because I think they've done some really good work and have been engaged, it would appear, with the ministry for quite some time in an effort to be very proactive and constructive in bringing forward proposed legislative amendments. Now, having, again, served on both sides of the legislature and understanding how legislation is created behind the scenes before it even appears in committees and in the legislature, there's two types of amendments. There's significant policy changes, new provisions of legislation that can often take a lot of work and can often require a lot of calculation and investment of time. And so then there's other types of amendments which are more housekeeping in nature. And the three trusts have written to their various elected officials, have provided copies of sort of a summary of proposed legislative amendments, and many of these are very simple. They would appear to be very administrative in nature, and it therefore would be it's perplexing to them, the trusts, and it's perplexing, I think, to others like myself as to why very few of these suggested amendments kind of work their way into the amendment we see here. And I hope that the minister will provide some insight into kind of the decisions that were taken to get us here, where aside from the $10 million top-ups and a couple items, a lot of these good suggestions were not included. So first one I wanted to ask the minister about was the trusts had proposed that enabling language be added to this legislation that would allow the trust to add Indigenous representatives to their regional advisory committees. This particular item has been recommended in each legislative review of the trust for years. It's consistent with the government's goal in Section 4.39 of the DRIPA Action Plan, and it was endorsed as a priority item by representatives from many local governments and the Indigenous advisory committees. It just strikes the trusts as frankly odd and unacceptable that Indigenous communities don't have a seat at this particular economic table. So I'm just wondering and this one is, I would not put in the category of housekeeping measure. This one is more about just, as we continue the journey down the path of reconciliation. I would really appreciate the minister explaining why this particular recommendation that the trusts have made has not been included in the Act, and it's not, so it was a valuable opportunity with these amendments to do so here and now.
Minister.
Thank you. Absolutely. There's no question about the importance of ensuring that First Nations have representation in all three of these trusts. That is deeply important work. That work has already begun. And this is a opportunity for us to ensure that the trusts are, particularly ICE-T, are not in risk of not continuing while we do that work. So the opportunity that funding the trusts at this moment in time gives us allows us to ensure their continued deeply important work while we do the quite complex and ongoing work of changing the nature of the governance of these trusts and who sits around the table at these trusts. So it's not that it is excluded, it's that this amendment, this $30 million, $10 million for three trusts, allows us the timeline needed to do that deeply important work.
Member.
Thank you, Chair. Well, DRIPA became law in this province, a number of years ago. This government's been in power through that whole time. So, could the minister explain why that work hasn't been done? Like, why is the allocation of $10 million more to each of these trusts over, as the minister put it, which provides an investment window of perhaps up to four more years of runway? Why is it that the investments we're talking about here today that provides the time frame to actually, on a forward-looking basis, do the work around including Indigenous representatives on these trusts, and as opposed to just having done the work over the previous years? One would have thought even that just in the time that this minister has been in this portfolio, there could have been progress made on this particular action. So I'm just wondering again. Understand that the minister's going to answer all the questions with the well, that's a forward-looking thing. We're going to work on that moving forward. It does beg the question about why wasn't that done as part of the process that led up to bringing forward amendments here today.
Minister.
Thank you, Honourable Chair. This work began in early 22, before I was minister. And the reality of it is that each of the different trusts and the different governance groups of the trusts have a number of different communities that they're working with and consulting with and collaborating with and having conversations with. And it's important work that takes some time. We are committed to this work being done correctly and successfully, but it's also important that the trusts know that they have the ability to continue their important work, so it's really a timing issue.
Member.
Does the minister have a time frame? Other, that's a little bit tighter than at some point in the future, or the 4-year runway ahead. Is this something that? Because we're talking about a seat on an advisory council, or a seat on these trusts that would be filled by an Indigenous representative. So it would seem to be fairly straightforward. So from a timing perspective, is the minister looking at perhaps bringing forward legislative amendments in the spring session next year, which would be that's good number of months away, to facilitate the inclusion of Indigenous representation on these trust advisory committees?
Minister.
Hello, Honourable Chair. Welcome to the Chair. This process is in fact being led by the Trust, and they and their boards will determine how long it takes. Once complete, we are committed to ensuring that the legislative changes that are necessary to ensure representation, proper representation with First Nations, are part of the governance of the Trust.
Recognizing the House Leader of Opposition.
Thank you. Yeah, welcome, Chair. So one last time, is there a time frame? Is there a time frame for this work to be concluded? That's the question. So the minister answered the previous question saying that there was, the work underway, the ministry's doing stuff, and then the trusts are leading the work. I mean, the ministry's flowing $10 million to each of these trusts. The minister said that it was very important, these dollars in part because it buys the time necessary to do this work, and I'm just looking for, on behalf of the trusts and I think Indigenous communities, what is the time frame? What is, from an expectation perspective, what would the minister like to see? What is the minister working towards to have these Indigenous advisory committees actually created and filled for that very important Indigenous representation?
Recognizing the Minister of Job, Economic Development and Innovation.
Thank you, Chair. And as I've mentioned, the time frame does live within the Trust. The governance of the Trust is leading the process and the consultations and the redesign of what this will look like. It's expected that that will occur within 2024, but the important thing is that this process is thorough and comprehensive and led by the Trust.
So read this. Recognizing the House Leader of a third party.
I'm somewhat, thank you, Mr. Chair, and through you to the Minister, I'm somewhat taken aback by the Minister's responses. Because as has been made very clear, that in 2022, at least the Island Coastal Economic Trust presented, and they're the only ones that I've talked to directly, they presented a comprehensive vision and case for investment. All of the minister's answers that have just been provided to my colleague from the official opposition House Leader were answered in that case. All of the questions that the House Leader of the official opposition asked about reviews have been done 9 times. It's a legislative process. 3 legislative review processes for each of the 3 trusts have been completed. The legislative review committees, the legislative review committee for the ICT, I'll speak to the one that I know most information about, came back and talked about how this vehicle, this community-led vehicle, is a critical community-led vehicle. They responded to that. The legislative review committee said, you have First Nations on there. So what did they develop for this minister, the previous minister? The document that this government has been sitting on for the last year was the first co-led trust. They recognized, as my colleague said, the 3 different trusts chose different approaches to how to spend that initial investment that was made by my colleague and his former colleagues when they were in government. The current leadership under the ICT has said, no, we don't want to have a sinking fund, one that disappears and goes away. We want to have a fund that is a solid community investment vehicle led by First Nations and local government community leaders. We see the vision. We've laid out a document how we're going to achieve that vision, and what we need is an investment from the provincial government so that we can start that. Founding money is what they've said. In fact, it went so far as to highlight for the minister the amendments that could be made in the Act in order to achieve this. So I'm astonished, actually, that the responses have been framed that we're waiting for the work to be done. The work, Mr. Chair, has been done. What hasn't happened is they haven't found a partner to make that investment. And at the moment that we had last spring, where the government had found, it went around the couch and shook the cushions, found billions of dollars, we didn't find an investment partner, even though the work had been done. So the question that I have through you to the minister, the first question is this: what does the minister consider the work of the legislative review committees in the context of the questions that my colleague were asking, which was a review of the effectiveness of the organizations and the impact that they've had, and then the recommendations that they made to this government?
Minister.
Thank you, Chair. I think we're talking about two different processes here. One is the periodic legislative reviews that occur approximately every 5 years. But the member is also talking about the proposal that we received from ICE-T, which included language and aspirations in regards to First Nations inclusion in governance. But that work is undergoing right now, and it's my understanding that that is not complete. And what we're looking for is all three of the trusts to complete that work, and then we'll move forward on legislation.
Member.
Thank you. So we had a situation where in 2017, budget 2017, the former BC Liberal government announced a $10 million rescue of the iced tea fund. It had run its course as has been profiled. It was established as a sinking fund, probably going back to the beginning of it. They might have done something different, but we didn't have the benefit of doing that. So the BC Liberals announced in that budget $10 million. The BC NDP ended up forming government after the 2017 election. They agreed with that budget allocation. They extended that money, basically kicking the can down the road. And the work, I guess I have a bit of a disagreement as to the state of where things are at, because I've been part of these discussions. I've had lots of discussions with my local government colleagues about where they feel that we're at, and I think what this debate has already been able to uncover is that the position that the trusts are in and the position that the government thinks they're in are two dramatically different spaces. There is, I believe, a philosophical difference between the work that the trusts want to do and the minister and the ministry and what they want to achieve from it. There was a remarkable opportunity for a commitment to be made to extend the life of the iced tea, but to extend the life of these three trusts at the time that we had a massive surplus. And so what's happened is the government has made the decision to extend the $30 million, and all the questions that were asked by my colleague about the analysis and making sure that there's value for money, all of those legislative review processes have found that these are useful community economic development vehicles. The type of projects that they support are the type of projects that build community, like community theater, critical docks for community connections. These are the things that basically this decision, rather than invest in these trusts long term, these decisions actually just kick the problem down the road another 4 years. And the reality is that the way that the answers here have been profiled is that we're committed to it. Well, but that has never been the indication that's been made. That's never been the inclination that is felt that the government is in support of this. Because the work, the lobbying, the advocacy, all of that has been excellent work, but it has fallen on a situation where we're given a short-term commitment of an extension of another $10 million. We're in exactly the same situation. There's no commitment on behalf of this government to the long-term investment that needs to be made. So what's actually happening is this money is extending the life. All of the work is being requested to be done with absolutely no certainty at the end of this. Is the minister suggesting that with this 4-year extension that these trusts have been given, that there is some certainty at the end of it that Indigenous people will finally be included in these funds? They'll finally have seats at the table being made decisions? There will finally be a sustainable amount of money that's being committed and invested by the province? Is that the context that we are to read from the minister's responses, that this is work that's in process and being done and that there's certainty at the end of it? Because the sense that I have is that there's nothing but uncertainty for these trusts.
Minister.
Thank you, Honourable Chair. Two things in response to that question. One is that the member, through you, Chair, is suggesting that the proposal reflected some degree of completion in regards to the consultation needed with Indigenous governments. We don't see it that way. In fact, looking at the 2022 proposal, I'll just share some of the writing included in it, which is, to quote, "Any legislative action should be preceded by sufficient consultation with Indigenous governments within the region and should receive their prior consent before being put before the Legislative Assembly." That's where they were in 2022, and we agree with that sentiment, of course, and that work is ongoing now. In regards to the question of certainty, two of the three trusts employed a different model of investment where they use an endowment model, and they are not at risk of running out of investment dollars if they continue to invest at the levels that they have been investing at. The one that did not, IST, has been investing approximately $2 million a year. The funding that we're bringing forward, should this bill be successful, is consistent with that funding. This allows them time to continue the quite excellent work, in fact, that they've been doing. But importantly, it provides us the timeline to do the work, to talk about the kind of certainty that the member is asking for, to plan with them on what the solution is going forward. We don't have it yet, frankly, and we have that work ahead of us, but we're creating the timeline to be able to do it.
Seeing no other questions, shall Clause 108 pass?
Aye.
Recognizing the member of Parkville, Qualicum.
Thank you, Chair. I move that Bill 42 be amended by adding a new clause, 108.1, to ensure that there is Indigenous governance representation at the regional advisory committees.
I call a 5-minute recess. I call the Committee of the Whole on Bill 42 back to order. We are now on Clause 108, and there's an amendment on the table right now. Does a member wish to speak to the amendment? Recognizing the member of Parksville Qualicum.
Thank you, Mr. Chair, and I want to thank the Minister for taking the time to answer these questions regarding this trust. The ICE-T, Island Coast Economic Trust on the island, is a significant economic contributor for those projects that have difficulty finding financing. It has been raised by colleagues from other parties here that there is a lack of Indigenous governance on the Trust's regional advisory committees. This was raised first, not in the 2011 legislative review, but it was raised when the Act was first introduced by members of what is now the governing party. There are two members that are currently sitting MLAs with the government party that advocated in 2006 for Indigenous representation on the regional advisory committees. This has been in the business plan. It has been in most of the strategic reports that strategic plans that this trust has put out, is a request of government to enable Indigenous participation on these RACs. Now, the minister began by mentioning that this trust is very independent from government, then said that government was working on consultation with First Nations to ensure that they had participation on this trust, then said that they're waiting on ICE-T to do this work. The fact is that the work doesn't need to be done at that level. We're not talking about additional funding. We're not talking about changing the governance structure in the sense of how to allocate that funding. We're just trying to ensure that there is Indigenous participation on the RACs. We have a meeting coming up in, I think, a week and a day, and MLAs are also invited to participate, but they don't often do. And if a First Nation governance body is unable to attend a RAC, there's no cost to that. There's no impact on that. We're not talking about changing fundamentally the structure of the organization, but to allow First Nations to have representation in these discussions. So the question I have, as I conclude my remarks here, is we have a very clear path to get that First Nations governance. It's been asked for nearly 20 years now. And the question is, I guess to the minister, is why is government not supporting this initiative?
I have reviewed the new proposed amendment and find that it is in order. I invite any member who would like to speak to the amendment to do so now. Recognizing the House Leader of a third party.
Yeah, thank you. I think that this aligns with the initiatives of the provincial government in recognizing we're having incomplete discussions if Indigenous governing bodies are not involved in organizations such as this. It's been made exceptionally clear that this is the desire of the trusts is to be inclusive rather than exclusive as they currently are. It was, as my colleague has said, it was raised by the government themselves that when they were in opposition that this was a missing component to Indigenous governing bodies or Indigenous leadership. Indigenous voices were a missing component to the voices at the table, and so I'm here to stand in support of this amendment.
Recognizing the House, recognizing House Leader of Official Opposition.
Great, thank you, Chair. I too, on behalf of the official opposition, am happy to stand in support of this amendment. I appreciate the work that my colleague from Parksville Qualicum has done in pulling the language together for this. Is it perfect? Perhaps not. But as I said in a number of my earlier questions here today, and the comments which have been echoed by the House Leader for the third party, and now the member from Parksville Qualicum, it's time to actually get on with taking action. There's a point at which talk and engagement and consultation and whatnot is important, but at a certain point, it's time to take action. This entire process, as has been detailed earlier today, has been going on for a number of years now, all consistent with the principles of DRIPA. And certainly when you talk to representatives of ICE-T, the Northern Development Trust, ETSI, they are all keen to advance this work and actually see it come to fruition. The other members of these trusts, the locally elected officials, they are already working with Indigenous communities, in varying degrees and varying ways, but they're all engaged. And they're championing this as much as the Indigenous peoples are, and certainly the rhetoric from government would suggest that this is what the government also supports. So really hope that the government will take to heart the efforts, I think, of the members of the opposition here across different parties and independent as well, that really are saying it's time to actually take the good work of these working groups, the planning, the engagement that's already been done, and actually set a firm timeline for actual implementation of the concepts, so that Indigenous peoples, Indigenous communities can actually be represented and have a voice, be party to these funding discussions, decisions, allocations, as they rightfully should be. So we would support this amendment. The final comment would be, we would want to ensure that all three trusts be dealt with equally in this manner, that all through the working groups across all three trusts that are engaged on these matters, that they all be charged with the responsibility within a firm timeline to actually, in partnership with Indigenous peoples and the provincial government and the locally elected officials, that they actually get on with making what's being proposed here, which has actually been promised to Indigenous peoples, that this promise, this commitment be converted into action, and that happen much, much sooner than later.
Minister.
Thank you, Honourable Chair, and thank you to all the members who spoke to this very important topic. And of course, our government is deeply committed to ensure that Indigenous voices and Indigenous leadership, Indigenous government is involved in these trusts. That's the work that we are doing. We were the first province to adopt UNDRIP. This is deeply important to this government, and we're absolutely committed to this work. We know that this work has been a multi-year process. That's the time that's been required. That's the time that the trusts are taking. The trusts are leading this process in conjunction with First Nations in their communities and in their areas that they're investing within. It's so important that Indigenous voices are at that table, and that will happen. It's why the Declaration Act specifically identifies this as an action under 4.39. And we have been working with the trusts. The trusts are leading this process to ensure that full consultation occurs, that the nations within their realm have been deeply involved in the recommendations on what that representation is going to look like. This work is undergoing right now. It's happening. It'll continue to happen in 2024. And once all three trusts have completed this work, we will move forward on legislation that puts it into law.
Oral amendment to add clause 108.1 shall it pass? Aye. Oppose? Nay. Nay has it. The amendment division has been called. Members, before restating the question, I remind all members that only the permanent members of Section C or their authorized substitutes may vote. The question is, shall Amendment 108.1 pass? Those voting aye, please rise or otherwise indicate. You may be seated. Those voting nay, please rise or otherwise indicate. You may be seated. Clerk?
Stone, Dirksen, Olson, 4. Those voting nay, Bailey, Heyman, Bear, Sharma, Kang, Glumac, Chow, 7.
The amendment is defeated. On clause 109, shall clause 109 pass? Recognizing the House part. My apologies, will wait. Shall clause 109 pass? Recognizing the House leader of third party. Oh, you go ahead.
Okay.
My apologies for recognizing the House leader of official opposition.
Okay, thank you, Chair. Just one question on this section, and this applies to the same funding allocation point for each of the three trusts, so I will only ask it this one time. But I wanted to reflect again feedback, or not just feedback, recommendations from the trusts with respect to the fact that there's a hard funding cap for each of the trusts, and the recommendation that the various legislative working groups have jointly brought forward would see there not being a mention of a hard funding cap. That right now in the legislation it says 50 million, and by adding the 10, obviously it goes up to 60. But the point is, why does there need to be a hard-coded 60 million, or it's a hard-coded number? And once, if this legislation passes, it'll be 60 million. The feeling is that this continuing with this hard funding cap is inconsistent with most other public bodies, and it's very operational, not governing. It's not a sort of a governing level as one would expect for legislation. It also makes it difficult for the government to ever truly, reinvest in these trusts without having to bring forward legislative amendments. So, just the question to the minister would be, why, or has the minister considered actually making a change to these hard funding caps? And if she has, why is there no consideration for that? And insofar as it's not reflected in the amendments that we see in front of us here today.
Minister.
Thank you, Honourable Chair. What I would say in response to the member's question is that this is a consistent practice with prior administration of the Trust, and it allows Legislature to have a say on the funding of the Trust and to allow for debate to happen in regards to what that funding level is.
Member.
Thank you. I just wanted to just clarify the record that I had said 50 million to 60 million, and I meant 60 million to 70 million. I know the minister, she's nodding her head. So, and obviously with the other two trusts, it's going from 50 to 60 million each. I guess again, I totally understand that this has been the practice to this point. The act is written the way it is. There have been a number of tranches of new funding advanced from successive provincial governments. So I'm just, I guess I'll ask one more question on this point. Is the minister open to considering changing this particular hard funding cap in the future and just leaving it open-ended so that future governments, this one and others, have the the additional flexibility of more quickly and easily advancing funding to these trusts as a government sees fit, without having to bring that specific measure to the Legislative Assembly for an amendment?
Minister.
I think what I would say to the member in regards to that question is that these trusts are set up to be quite independent, and I think it's really important that Legislature have the opportunity to debate and have thorough discussion about the level of funding that goes into this trust, and those caps do allow for that debate to occur.
Recognizing the House Leader of a third party.
Yeah, thank you. Again, I think that it's important for us to just to reflect on some of the responses that have been given. A consistent practice, when the minister suggests that this has been consistent practice. Consistent practice is, I think, one time. I think one time in 2017 when the ICE-T, Coastal Economic Trust, had gotten to the end of its money. And the consistent practice of the time was to kick the can a little further down the road, 4 years. Well, here we are at that same rusty can. And the government was given the opportunity to either put some foundational funding in place so that fund could be robust and be a community investment vehicle over the long term. Chose not to do that. Chose instead to change the from 60 to 70 million to do the consistent practice of the one time that it happened previously, as best as I can see. The other thing which is interesting is that if we're going to use the language of consistent practice, then let's apply it consistently. Because I kept hearing over and over and over again, as I was advocating for this over this past year, that they couldn't act on behalf of the ICE-T without acting on behalf of the other two trusts that were there. Because the ICE-T, admittedly, even all of the board of directors, everybody around the table understands that the decision was made way back in 2006 that it was going to be a sinking fund. They have a different vision for that. They've expressed that different vision. And so the consistent practice, if this government was going to follow consistent practice, as the minister suggests today, then it would have been fine to just have an engagement with the ICE-T, recognize what they need in their unique circumstances, and engage them in that, instead of creating this narrative that you can only have a conversation with all three of these independent, and they're all three independent of each other. That's the reason why Section 109, Section 113, and Section 116 have to be independently amended. if they were all the same thing, if they were all just one thing, we would just have to amend it once. But what is inconsistent is the way that the government is practicing. That's what's inconsistent. And yet we sit here today and hear that what we need to follow is consistent practice. When really, actually, what we're doing today and in this process is creating a consistent practice, because you can't have a consistent practice until you have, I think, more than just a single instance of something. So with that, I'm going to actually give the opportunity of the government and the opposition to an opportunity to actually remove the cap and repeal clause section 17(1) of the Act and repeal it from that Act. So I'd like to move this amendment.
The member has moved an amendment, notice of which has been provided, and the text of the amendment is printed on the order paper. Would the member like to speak to the amendment, proposed amendment?
Yeah, and
recognizing the House Leader of a third party.
Thank you, Mr. Chair. I think it's important just to reflect that this is a request, this has been the request of the ICE-T. This is the direction that they would like to go. They would prefer that there is no cap. This doesn't require more consultation of the ICE-T. That doesn't require more conversations with the mayors and councillors that make up those racks. It shouldn't require more consultation or discussion with the MLAs that sit or should be sitting on those racks with the community leaders. This is the request. This is what the community has requested of this government. If it's not supported, then this is the government who, not following the recommendations of the review committees and of the ICE-T. So I strongly suggest and strongly hope that the government will repeal this and give themselves the flexibility to act and to be, I was hoping that this government would be inclusive of First Nations. They've shown a desire not to be. And what I'm hoping is that they will follow the advice of the Island Coastal Economic Trust and support this to repeal this section of the Act. Thank you.
I have reviewed the proposed amendment. By proposing to remove a limit of the proposed amendment has the effect of increased expenditure of public funds, and it has an expenditure by implication. Therefore, this proposed amendment is not in order. Now, returning to reconsidering the clause 109, shall clause 109 pass? Recognizing the House Leader of a third party.
Thank you, Mr. Chair, and I appreciate your ruling. I'm just wondering if you could provide some greater rationale than that. I'm not proposing the government spend any more money. I'm just proposing that the government doesn't have a limit and could still choose to give $1, could still choose to give $10 million, or could give more than that. But this proposal is not suggesting that the government need to spend the money. It's just removing a restriction that it is unnecessarily put on itself.
Thank you so much. The amendment itself actually opens up expenditure limits, and therefore has expenditure associated with which is, sorry? Yeah, so it allows expenditure, so indirectly will access government funds. Recognizing the House Leader of a third party.
Yeah, so thank you, Mr. Chair. Is the chair taking the position then that this motion obliges the government to do something?
I believe this motion actually creates an opening and allowing people to actually access to government funds, and therefore I'm going to say it's not in order. Recognizing the House Leader of a third party.
Yeah, thank you, Mr. Chair. I would just, I think, with respect, just say this motion doesn't open up any more opportunities than the government takes themselves. This is simply just saying that this cap, which has been created by previous governments, has a limitation on government. So I recognize that aspect of it. However, it doesn't require the government to spend any more money. It just creates an opportunity for it in the future to make a different decision than the one that they're making today. And it actually opens a door for them to be able to, make a different decision than the one that they're making today. So it's a curious ruling, but I accept it. Thank you.
Thank you, member. Now going to clause 109, shall 109 pass? So ordered. I'm asking minister to noting the hour. Minister.
Thank you, Honourable Chair. I move that the committee rise, report progress, and ask leave to sit again.
Members, the question is that the committee rise, report progress, and seek leave and to sit again. Those in favor indicate aye. Those opposed indicate nay. Motion is carried. The committee now stands adjourned.